My name is András Bajnóczi, and I'm going to talk about the AAA, the persons unknown case. This case, this case's background was that an English insurer insured a Canadian insurance company, which was hacked and asked to pay ransom. The company, the insurer, paid $950,000 for a decryption tool, and with this tool they successfully decrypted the compromised files, and they solved the problem. The agent of the insurer paid 109.25 bitcoins to the defendant, and with a specialist which was involved by insurer, they tracked down the bitcoins, and they successfully tracked 96 bitcoins, which was sent to Bitfinex, operated by third and fourth defendants. It is a procedural issue, but the hearings were held in private because they would like to prevent to unknown person to dissipate the bitcoins, or and there was a risk of further cyber attacks, for example revenge attacks or copycat attacks. The relief that was sought by applicant was that the court to order the third and fourth defendants to provide specific information about the first and second defendant, and they also asked for proprietary injunction and freezing injunction. This interim measure means that the frozen asset is said to belong to the insurer. The court find a problem that is Bitcoin property at all, because these measures can be issued in context of property. This was so the difficulty that can Bitcoin qualified as property? By the definition given by the case Colonial v. Vinny, was that all personal things are either in possession or action. The law knows no tertium quid between the two. By this definition, Bitcoin cannot be qualified as property, so the interim measure cannot be issued. However, despite this definition, the UK Jurisdictional Task Force published a legal statement on crypto assets and smart contracts, and in this statement they refer to several cases where the definition of property was discussed. There were cases as well where the courts found no difficulty in treating novel kinds of intangible assets as property, for example milk quota or EU carbon emission allowance. And there were also examples for the definition of property which are covering things other than things in possession or things in action, and these definitions can be found in Theft Act, Fraud Act, or Patents Act. And also there were cases, for example the case of Liam David Robertson, where cryptocurrency was treated like property. The criteria the four criteria to consider Bitcoin as property was set out by Lord Wilberforce in National Provincial Bank v. Ainsworth case. These four criteria were that the asset has to be definable, identifiable by third parties, capable in their nature of assumption by third parties, and having some degree of permanence. The court found that Bitcoin checks out all the criteria, and therefore it can be viewed as a property. Because it can be because it constitutes property and all of the other criteria were met. Therefore, the proprietary injunction has to could be issued. Thank you for your attention.